Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which is, Loretta, you can do it with me, the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. Ladies and gentlemen, it's always constitutional heaven here at the National Constitution Center, but we're coming off of one of the most exciting weeks since I've been here, and that was Constitution Day, where 4,000 school kids gathered at the NCC on Thursday. Justice Breyer was here, and the head of the College Board and I announced the launch of the new Interactive Constitution, this really thrilling new educational tool that has united the best scholars in America, liberal and conservative and everywhere in between, to write about every clause of the Constitution, describing both what they agree about and what they disagree about. And the College Board announced that it's going to make this the center of the new AP History and Government exams, and that eventually we hope to bring it to every student in America from 8 to 80, because this is the only place where citizens across the country can find civil dialogue about the Constitution that doesn't shy away from disagreements, but also finds common areas of agreement. And it's thrilling, and I just can't wait to share it with you. And I want you to go online at constitutioncenter.org and check it out, and learn from it, and expand your constitutional knowledge. And what our gathering tonight is a wonderful follow-up to that exciting evening, because here we have gathered, and I say this without any exaggeration, the 4 greatest scholars of religious liberty in America. And they come from very different perspectives, and we were just in the green room, and I made the obvious joke about Jefferson dining alone, because this group is not usually convened in one place. And to make matters even better, several of them have contributed to the Interactive Constitution. And if you click on the First Amendment, you will find Michael McConnell and Marcy Hamilton describing their areas of agreement and disagreement about the Free Exercise Clause and the Establishment Clause of the Constitution. And it is meet and appropriate that we summon them here today, because this is the beginning of World Families Week. The Pope will be on Independence Mall on Saturday, delivering an address at the podium from which Abraham Lincoln gave the Gettysburg Address. And to honor his visit to Philadelphia and to America, we've opened up a beautiful new exhibit on religious liberty and the American founding that Marcy Hamilton helped us curate, along with Danielle Evans, our wonderful senior fellow for constitutional studies. Go downstairs after the show and see it. It's in the Annenberg lobby, and you'll see treasures of religious liberty, including one of the 2 signed copies of Washington's first Thanksgiving proclamation, where he gives thanks not for Thanksgiving, turkey, but for the Constitution, as well as Jefferson's letter calling for a wall of separation between church and state. What we need to talk about today, and we have a lot to learn from the people who know more about this than anyone else in America, is what the framers had in mind when they drafted the beautiful words of the First Amendment, which I will read once I introduce our panel, and what agreement and disagreement there is today about what they were trying to achieve. So with that completely narrative introduction, because I'm just telling you how exciting it is that we have these 4 scholars, please join me in welcoming our panelists. Marcy Hamilton, Doug Laycock, Michael McConnell, and Philip Hamburger. I feel like a constitutional barker at times, a kind of talk show host, but for this particular group, it is really worthwhile, because I'm so honored to welcome them here today. And of course, just whet your appetite, after hearing from them, you're going to hear from 4 of the most thoughtful people in America about contemporary questions about religious freedom. But we're going to begin with history. And I wish so much that I had just hooked up the Interactive Constitution so I could display it behind you. But I want to begin with Michael McConnell and Marcy Hamilton, who wrote about the Constitution, and they wrote about the Establishment Clause. And Michael, you have a common statement about the history of the Establishment Clause. I would have thought this was one of the most contested in all of constitutional history, but you wrote a common statement. How long did it take you to agree about the settled meaning of the Establishment Clause?
Oh, I'd say a couple weeks, maybe. Actually, by the end, we had one major disagreement, which was over the role of Catholics in Maryland at the end of the 17th century. which is a pretty technical point. The reason it didn't take any longer is you only wanted 800 words, and so we could leave out all the contentious stuff.
And what was the disagreement about Catholics in Maryland?
I take what I think is the traditional view that Maryland was founded as actually the most free exercise friendly of all the early colonies. It was founded by a Catholic proprietor for the benefit of Catholics so that they would have a place where they would be able to go and be able to worship in peace, but extended also to others. And Marcy has a somewhat more somber sense of the Catholic role.
Marcy, what is your somber sense?
Well, I was looking more at the history of the conflicts between Catholics and Protestants that showed that the Catholics really did have some serious control. And I'm a real believer in a functional understanding of the Establishment Clause and the separation of church and state. So I didn't really care if they called themselves an establishment, but the discord was pretty ugly at times. But we agreed to start out the whole thing by saying that the United States was settled by Catholics and Protestants and Jews, and that was my main concern, that we made sure that we mentioned more than just the Protestants at the start.
And you did indeed. The first paragraph of this great explainer says, America's early settlers came from a variety of religious backgrounds. Puritans in New England, Anglicans in the South, Quakers and Lutherans flocked especially to Pennsylvania, Roman Catholics in Maryland. Presbyterians were the most numerous in the Middle Colony, and there were Jewish congregations in 5 cities. It's so clear, and several of the people who saw this on Friday said it's just a model for prose and for teaching school kids about English language arts as well. And I think David Coleman also wants to do that because this is written for citizens. It's not for lawyers. It's nuanced. It doesn't dumb anything down, but it is just thrilling to have all of this in one place. Okay, we have so much to talk about. I said I would read the Establishment Clause, even this interactive, this pocket constitution, which I never leave home without, with its thrilling introduction by yours truly and David Rubenstein, is now made almost obsolete.
I didn't even know you were around back then. You wrote the intro?
It was incredible. You know,
We the people?
It took a long time, but you know, it's a tough job. Someone's got to do it. You can now find that essay as well online. But we'll begin with the words of the First Amendment, which you know from reading our Bill of Rights. One of its 12 original copies was originally not the First Amendment, but the third. When you go to see the original Bill of Rights and also the first public printing downstairs in the Religious Liberty exhibit, the first article had to do with apportionment in Congress and said there had to be one representative for every 30,000 inhabitants. There'd be 4,000 Congress people if that had passed today. It was a coincidence that their Third Amendment became our first. And therefore, the famous language of the First Amendment, which says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, far from being at the top of mind, just became the First Amendment almost by coincidence. Philip, you have, you know, I haven't even got so excited I haven't properly introduced our panelists, which I will just do in the briefest way as I call on them for the first time. Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. Really, as I said, like his colleagues, the leading scholar in the country about the constitutional history of the First Amendment, and his most recent book is Administrative Law Unlawful? Let me begin with a hot button question about establishment that always allows me to use an SAT word, which is anti-disestablishment. And there are some scholars, and I wonder if you're one of them, who say that the point of the First Amendment wasn't to prohibit any state endorsement of religion. It was to prevent the federal government from disestablishing state churches like Anglicanism in Virginia and the other ones that Michael and Marcy write about. Is that anti-disestablishment interpretation convincing?
Right. It's a wonderfully clever interpretation of the First Amendment. One reads it and one thinks it's really about religious liberty and disestablishment. And then come along these academics who say, well, actually, it's cleverer than that. It's really just designed to protect state establishments, the very opposite, as it were, because it only seems to bar, perhaps it's jurisdictional, only seems to bar laws respecting establishment of religion, and that leaves room, of course, for the folks who had state establishments, as my home state, Connecticut, had an establishment until 1818, Massachusetts until 1830. If there's to be no law respecting an establishment of religion, that actually prevents federal laws, Congress from passing a law that would interfere in state establishments. And certainly, this makes it politically acceptable, I think, to the New England states, who many of them revered their establishments. But is that to say that it's merely jurisdictional, that it doesn't protect religious liberty? And I would emphatically disagree, as would, I think, most of the religious dissenters in early America. They thought they had won their religious liberty with the Establishment Clause.
Fascinating. Douglas Laycock is Robert E. Scott Distinguished Professor of Law, class of 1963, research professor in honor of Graham C. Lilly and Peter W. Lowe, and a professor of religious studies at the University of Virginia School of Law. That is the coolest chair title I've ever heard. That is very impressive in its scope.
Try to take care of our donors.
Very nice. We should take a book from that. Do you agree with Philip?
Generally, yes. So plainly what the Protestant dissenters who successfully demanded an Establishment Clause wanted was no federal establishment. I think it's also equally clear it didn't enter anyone's mind that the federal government would disestablish or interfere with the state-established churches. No one thought they had power to do that. No one thought it was politically feasible to do that. So it wasn't going to happen. But the argument you raise carries us one step further and says, it's got this funny word, respecting, and it means concerning, done with respect to. Right? Any law with respect to an establishment of religion could include, literally, textually, a federal law interfering with the Massachusetts establishment. Philip's read a lot more of the original writings and so forth than I have, but I've read quite a bit. I've never seen anybody argue that or suggest that was what they were trying to accomplish. And here's a factoid. On that interpretation, if that's what it was about, to protect the state establishments, it was a particular favor for Massachusetts and Connecticut, who had the most fully developed establishments. They didn't ratify until 1939 on the 150th anniversary. If it was for them, they didn't want it.
Fascinating. Any takers for anti-disestablishment? Michael, do you think there's anything to it?
I don't think anti-disestablishment was the point, but there was an original version which did not say Congress shall make no law, and it did not say respecting an establishment. It was just, there would be no establishment. And there was a debate in the first Congress where a representative from Connecticut points out that that language could have disrupted the Connecticut establishment, because if two people sued in federal court if somebody failed to pay their mandatory tithes to their church, which is the essence of the establishment, and then they were sued in federal court, that the federal court could say, no, the Constitution prohibits an establishment, and thus sort of indirectly through the courts destroy the establishment of Connecticut. And I think that that's the reason they added the words Congress shall make no law, and also the respecting came about, because the principal point was not to have a federal establishment, but they were concerned not to disrupt the state establishment at the same time.
Great. And I should say that Michael McConnell, in addition to being the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford and Senior Fellow at the Hoover Institution, is a former judge on the U.S. Court of Appeals for the 10th Circuit, where he served with great distinction. Marcy, we have this wonderful religious liberty exhibit downstairs, and I need to give a shout out and a sincere thank you to Seth Kaller, who is here. He helped us assemble from the greatest document collectors and philanthropists in the country these precious treasures of religious liberty. They lent them generously and quickly, and thank you, Seth, for putting this wonderful exhibit together. Marcy, you, first of all, let's remind you have an incredibly fancy and impressive title as well, and right now the bar is kind of high for endowed chairs, so yours is the Paul R. Verkuhl Chair in Public Law at the Benjamin N. Cardozo School of Law at Yeshiva University. You helped us curate that exhibit, and in the middle section of it, you can watch the evolution of the language that became the Establishment Clause. The House originally had said that they wanted to prohibit an establishment of religion, but the Senate had a softer version that said Congress shall not have any articles of faith. Was that a softer and less restrictive notion? And I gather the House pushed back and won, but what was the Senate trying to achieve with that language?
Well, there was a concept that was the basic premise of the entire debate, which was that the framing generation understood what a theocracy was like. And the concept was that they were trying to formulate a way not to have a national theocracy. But the truth of the matter is, and I think Leonard Levy does by far the best work on this in terms of the history of this, the Establishment Clause just planted a seed. And so that language, I honestly don't think either side fully understood the full import of the language. And we ended up with an Establishment Clause that only applied to Congress by words. But by 1833, there were no establishments left in the states. So it's my view that that debate is the seeds for the increasing disinterest even in the states for an establishment.
Or disestablishment.
Disinterest for establishment.
Michael, what were quintessential examples of establishment? You can see downstairs in the exhibit George Washington having to sign a test oath in order to serve as a member of the Virginia military. He had to forswear transubstantiation and other Catholic doctrines. And then William Penn, in a book printed by Benjamin Franklin, says that anyone who professes to believe in Jesus Christ can hold public office. That was a more liberal provision because you didn't have to be a member of the established church. Is that what they were worried about, or was it something else?
You need to look at the set of laws which established the church. So the church bylaw established in Britain was not one law, but essentially four. So there was the Supremacy Act, which gave the king or queen, the monarch, control over the church. That's government control over the church. This actually wasn't a theocracy. It was the opposite. It was government-controlled church rather than church-controlled government. So the Supremacy Act makes the monarch the head. The Uniformity Acts create a uniform set of liturgy. That's the church, the Book of Common Prayer, and the Articles of Faith of the Anglican Church. That's actually what the Senate was getting at when they said there will be no articles of faith or modes of worship, is they were essentially saying we'll have no uniformity acts, and all churches had to conform to those. So you could not have a public worship service other than in accordance with the liturgy and articles of faith of the Church of England until the Toleration Act, which allowed 4 Protestant denominations to deviate from portions of that. Then the third was the Test and Corporation Acts, which prohibited anyone from holding high office in the government or the military, and that included dons at Cambridge and Oxford, and this is what George Washington was swearing to. The Test Act required you to swear that you did not believe in the Roman Catholic doctrine of transubstantiation and that you had attended and received communion in the Church of England within the last 6 months. That means that no one can, you can be an ordinary subject of the king in England without conforming to that, but the entire leadership of the country has to be part of the Church of England. And then finally, there were laws requiring religious tithes and attendance. So those are the 4 headings under which the Church of England was established. I think that the Establishment Clause prohibits all 4.
Great. So that is the core meaning, and there's agreement about if the government were to compel tithing, that would be an establishment. And the question we now have to explore is how much further the Establishment Clause goes. In the exhibit, we have a reproduction of Thomas Jefferson's famous letter to the Danbury Baptists calling for a separation, a wall of separation between church and state, and an original copy of his letter to a different group of Baptists talking about the protection of the rights of conscience as being among the triumphs of the Revolution. Philip, you have written an important and widely discussed book against separation in 2002, and you say, the standard claim on behalf of separation is that it was the religious liberty demanded by 18th century religious dissenters, But you say, in fact, American dissenters made demands for religious liberty that were different from separation, although the evangelical dissenters who dominated the campaign relied on numerous arguments. They tended to demand constitutional protections of two types: equal rights without respect to religious difference. More broadly, law should take no cognizance of religion, but you reject the idea that there was supposed to be a complete wall of separation. Tell us more about that.
I think we can begin with the text, and it's rather amusing to think about the overlap between the phrase separation of church and state and the phrase in the Constitution, Congress shall make no law respecting an establishment of religion. What's the overlap between these phrases? And I think it's that very important word "of." And once one realizes how little overlap there is, one can begin to explore this seriously. The dissenters in 18th century, the religious minorities in 18th century American states, many of them, in fact, most commonly demanded equal rights that would not be punished with respect to one's religion or non-discrimination. And the smaller number, and they were joined by Madison, said there should be no laws respecting religion. And what's interesting is the Establishment Clause in the First Amendment adopts neither of these provisions. It says no laws respecting an establishment of religion, which means it is okay to have laws regarding religion, which means that this is not simply an equality standard. In other words, one can have laws favoring religion. And what they certainly didn't do is talk about separation of church and state. Separation of church and state actually is popularized and becomes well known at this time, mostly not as a demand for religious liberty, but as an accusation. The establishment ministers who want to disparage dissenters asking for religious liberty, establishment ministers would say, we know what you really want. It's not religious liberty. You want a separation of church and state, separation of religion and politics, which is a way of saying, you dissenters, you're really against morals. You want to separate government from religion, which is the foundation of morals. So the real question is how this all got flipped around, and this became our interpretation of the First Amendment, and that's an interesting story.
I'll ask more about it in a sec, but I want to note a review of your book by Doug Laycock, The Many Meanings of Separation. Doug, you said Philip Hamburger shows conclusively that separation has a long and dishonorable tradition as a rationalization for Protestant suppression of Catholics and for attempted secular suppression of all organized religion. Hamburger surely errs, however, in taking this meaning for granted and imputing that meaning to everyone who invokes the same concept, but it seems undeniable that Hamburger's meaning of separation is one meaning. Amplify, please.
Well, part of the problem with separation of church and state is it is just a slogan, and different Americans have used it to mean radically different things. Even the Puritans believed in separation of church and state, but they meant institutional separation. Ministers couldn't hold elective office. The institutions of the state and the institution of the church were entirely different. Plenty of people were talking about keeping the church and state apart, keeping them separate, government taking no cognizance of religion, government is not a competent judge of religious truth, the dissenters said during the founding period. The phrase separation of church and state, I agree with Philip, didn't become widespread and popular until the anti-Catholic moves in the mid-19th century. So there's an honorable tradition of separating the religious activities and belief of the American people from the power of government. And you do that by not letting the church pick one religion and promote it, by not letting the church regulate religion, by not letting the state regulate religion, not letting the state interfere with the religious practices of the people except where it's necessary. Religious exemptions are a form of separation of church and state. And there was this rhetorical tradition from the middle of the 19th century up to the middle of the 20th, really, that was using church and state for a set of demands that was heavily anti-Catholic and for a smaller group, anti-religion in general. It's pretty clear that's never what the Supreme Court has meant when it talks about separation of church and state. It doesn't talk about it much anymore. But in the period from the end of World War II to the late 20th century, when the Supreme Court talked about separation of church and state, it understood separation as a way of ensuring government neutrality towards religion. I think that's an honorable tradition, but the problem is so many people have used the phrase in so many different ways, it doesn't really help much anymore.
Jeff, could I add something to that?
Please do.
I really don't think that it's possible to talk about the separation of church and state without giving a nod to the Baptists. The Baptists were the original group that actually came up with the idea that there would be such a separation. And the reason they needed to is because they were being oppressed by the established church, primarily in Massachusetts. So the concept is as much functional as it has these more text-based reasons. And I think that is the operative way to understand it. I also reviewed Philip's book, and my disagreement with Philip with respect to separation is that I disagree with the concept of anti-Catholicism as the basis for separation. It's anti-papism, which is a very interesting concept to have the week that the Pope is coming to Philadelphia. And if you read carefully the works of James Madison, there was an anti-clerical concern at the framing, and there was also a concern later in the 19th century, and the concern was whether or not Catholic citizens were going to have allegiance to the Pope, or they were going to have allegiance to the form of democratic government here in the United States. I disagree with the concept that it was just anti-Catholicism. I think it's a perfectly legitimate question to ask, and of course it was asked of JFK, and JFK answered it that he would be true to the laws of the United States and would not be controlled by the Pope. So that is something that needs to be part of the discourse. Anti-clericalism is actually part of the American history of understanding the control of religion, but also the freedom of religion.
Michael, I want you to chime in and also give a sense of what you think of Philip's thesis, and then of course Philip can respond.
First, that's what anti-Catholicism is in America, is the belief that Catholics cannot really be full citizens of this republic because of their allegiance to Rome. It's true it was a concern, and the concern goes by the name of anti-Catholicism. It's true that it was dispelled by John F. Kennedy, but that's the concern that he was addressing. So I don't see why we don't give it its name. Now, I don't entirely agree with Philip either. Philip, I think all four of us have a slightly different sense of this, but let me say what I think was at stake when Jefferson wrote his letter, because I believe that the concepts of forbidding establishment and forbidding interferences with free exercise are specifically addressed at the power of the state. These are things that the state does. These are types of laws that the state uses to regulate religious activity. The subtle change from no establishment to separation, when you think of separation, you're now thinking about both sides as if the First Amendment somehow requires religion to be separate from government. And I don't think that that is an accurate understanding at all, but I do think that that was Jefferson's political motive when he wrote that letter, because as you may know, that he was widely derided, especially in New England, because of supposed atheistic tendencies, and in particular, clergy in New England were quite vicious in their attacks on him. Anybody who thinks, by the way, that modern politics is somehow less negative and contumacious than the founding hasn't read much about the politics of the founding. So Jefferson was upset that these New England clergy were attacking him for being an atheist, and separation of church and state was his subtle way of sort of twisting the First Amendment in order to make it look as though there was something improper about that. And in fact, I think that there is nothing in our First Amendment tradition that forbids churches from being as involved in politics and as any other private organization. What the First Amendment is about is restricting the powers of the government with respect to religion. It's not restricting religious citizens with respect to their ability to try to influence public affairs.
Philip, I want you to respond to the scurrilous criticisms of all four of your colleagues. Of course, they're respectful, but in the course of doing that, help clarify for our audience what's at stake. On the modern Supreme Court, the strict separationists, and perhaps Justice Ginsburg would be a quintessential example of them, insist that the Establishment Clause requires neutrality between religion and irreligion, and another group of justices led by Justice Scalia say that the government has to be neutral among sects, but not between religion and irreligion. Is that the dispute that you're having, or is that a different one?
Yeah, so what's at stake here, and I think it's a good idea to step back a little bit from this, because it's not really about our scholarship. There's something very important, a high principle that we all have a stake in here. And the question is, should we look at the Constitution's words in the First Amendment and try to understand them as laying out a delicately drafted religious liberty? Or should we parse this, interpret it in terms of a popular slogan, in this case, separation of church and state, or you could add neutrality if you wish? And this has been a project that's been taken up by many. Some are anti-Catholic. The anti-Catholics, not least here in Philadelphia, popularized this in the 19th century. It's why a church about 2 blocks from here got burned down in some riots in 1844. But it's not just anti-Catholics. There are also many theological liberals who were worried about all church influence. And Thomas Jefferson was one of these, and the post-war Supreme Court sort of joined this crowd. But leaving aside this division between the anti-Catholics and the more generally anti-Christian, anti-church types, what's at stake here is, do we parse the First Amendment in terms of separation of church and state? And think about what's at stake here. The Establishment Clause is about Congress or government supporting religion, establishing religion. It's like a vertical metaphor, if you will. Separation of church and state can be understood more as a horizontal metaphor. It's about keeping these institutions apart. In other words, separation no longer simply limits Congress, it limits also religion. And that's not in the First Amendment. What's more, it discriminates amongst religions, because instead of saying separation of religion and state, it's about churches, it's about organized religion as a particular danger. And you can see why this lent itself to anti-Catholics. So this becomes a very discriminatory phrase that's used to parse what actually was a marvelously drafted piece of constitutional law.
Beautiful. Well,
If I could take one more sentence.
Please do.
The fundamental point of disagreement is that this was never the view of the Supreme Court in the middle of the 20th century or later. The theological liberals that Philip talks about, I agree, they were there, they were for real. They had 9 demands. They got none of them from the Supreme Court. Wasn't what the Supreme Court meant by separation of church and state.
I'm turning to my interactive constitution. So far, we've really been focusing on the Establishment Clause of the First Amendment, and we need now to turn to the Free Exercise Clause of the First Amendment, and we can do that by going to the interactive constitution and pressing the clauses and finding Fred Geddix and Michael McConnell wrote about the Free Exercise Clause. Michael, tell us about how you and Fred came to agreement, and what did you agree about, and what did you disagree about?
We actually, I think it's fair to say what we agreed about is what is the current disagreement, because there's, if anything, more disagreement about the meaning of the Free Exercise Clause than the Establishment Clause, and but it's less complicated. There are essentially 2 views, a little oversimplification, but essentially 2 views. The First Amendment says Congress shall make no law prohibiting the free exercise of religion. I think everybody now agrees, although the Supreme Court for a very long time said the opposite, but everyone now agrees that exercise of religion means putting it into effect. That does not mean you can just believe what you want to believe. It means you can put your beliefs into effect. That's what exercise means. But one view says that the government does not violate that unless it singles out religion on a discriminatory basis and says, you can't do that because of its being religious. So for example, some zoning ordinances would allow you to have a meeting hall, but not a church. That would be singling out religion for a particular prohibition as a religious meeting rather than generally. And then, but that view says that if there's a law that applies across the board, that it doesn't violate the Free Exercise Clause. So if, for example, you had during Prohibition, if there had been a law that said no alcoholic beverages can be supplied, that could outlaw the Mass or the Jewish Seder or other sacraments that use wine, and that there would be, and the Free Exercise Clause under this first view would provide no protection for the exercise of religion against a neutral and generally applicable law. The other view is that the Free Exercise Clause is triggered whenever the exercise of religion is prohibited. That is to say, whether it's a neutral and generally applicable law doesn't matter. If it prohibits you from exercising your religion, then it is covered. Now, this presents another problem because it can't be covered absolutely. There are many things that people might want to do, might need to do from a religious conviction that can't be tolerated in a civil society, that do violence to others or disrupt the public good. And so under this view, you have to have some kind of implied limitation. What the Supreme Court has said is that's a compelling governmental interest. That's a notoriously slippery formulation that I doubt anybody up here particularly approves of. So the first view has the problem that it doesn't actually seem to protect religious exercise against, perfectly expectable problems. The second view has the problem of having to craft limits that are not in the text and that are very difficult to formulate.
Thank you for describing those two views so well. Those limits will be the subject of our next panel, in particular whether people should get exemptions from generally applicable anti-discrimination laws if they're religiously observant. Philip, I want to ask you more about the natural law history of the Free Exercise Clause. One of the thrilling things that the interactive Constitution does, in addition to uniting the finest scholars in America for agreement and disagreement, is allows students of the Constitution, that's you, to click on any provision of the Bill of Rights and see its historic antecedents. You can watch the language evolve from the Revolutionary era state constitutions, and thanks to Seth and Marcy, you can see original documents of those drafts downstairs. The Virginia Declaration of Rights, and we have a rare printing downstairs, and you can see it online, was written by George Mason, inspired both Jefferson when he wrote the Declaration and Madison when he wrote the Bill of Rights, and talks about the unalienable rights of conscience, the people's unalienable right to worship God according to the dictates of conscience. Philip, what did it mean for the rights of conscience to be unalienable, and what is the significance of that for the free exercise debate?
Right, so this is actually one of the great achievements of early America. The First Amendment, like the Virginia Declaration of Rights already in 1776, treated religious liberty as an inalienable right, and that is an unconditional right, one that was not subject to any conditions or qualifications at all. This had not been true in England. In England, there had been merely toleration, which was a great achievement in the 17th century, but looked rather lame by the 18th. And toleration was a conditional liberty, such that the government could, if you didn't meet its conditions on your beliefs, interfere with your freedom on account of your religion. And this leads to questions about the debate that Michael was talking about, because if one's liberty is so broad that it's subject to qualification with a compelling government interest test, it's beginning to look rather conditional. And if I might step beyond just this one clause to think about all of our Bill of Rights, we have a structural problem in framing rights. One can draft a right narrowly enough that it's unconditional, that it's never qualified. Or you can draft it very broadly, but then you have to say, well, some instances you don't get it. And the framers of our Constitution, I think, as Madison actually carefully laid out in one of his letters, October 17, 1788 to Jefferson, explains you have to draft your Bill of Rights narrowly, have narrowly protected rights, because those will always be secure and there'll never be an excuse for violating them. And the danger of a broad religious liberty that is an exemption from general laws is that it will be qualified, it will be conditional, and that undermines, I think, the profound achievement we had in the 18th century.
Doug, say more about what it means to be an unalienable right. The framers believed that unalienable or natural rights came from God and not government, and when we moved from the state of nature to civil society, we couldn't surrender or alienate those rights to government, even if we wanted to. And as I understand it, conscience was an unalienable right because my religious beliefs or non-beliefs are the product of external sensations operating on my reason. And as creatures of the Enlightenment, the framers believed with the Scottish Enlightenment thinkers that our rational conclusions, our ability to reason, couldn't be alienated to government. What is the significance of that for the First Amendment today?
I'm not sure it has a whole lot of continuing significance. It is part of our continuing theory, political theory, that our rights are unalienable, that we can't give them back or surrender them to government. But that doesn't tell us how to interpret them as they are embedded in the Constitution and as they continue to exist. The Enlightenment thinkers you point to were one important strand in 18th century thought. The more numerous strand in terms of the religion clauses, the groups that delivered the political muscle to insist on a guarantee of religious liberty were the Protestant evangelicals in the 18th century. But they had a similar view that salvation was so important, every man and woman had to decide for himself or herself, and no one, certainly not government, could tell you what you were supposed to believe about religion. They were a much less religiously diverse society. They were about 99.5% Protestant, and there was much less regulation. Government was very small. And so the issue of religious exemptions for religiously motivated conduct didn't come up very often. When it did come up, they dealt with it case by case, and they generally granted exemptions. So Quakers didn't have to serve in the military. They didn't have to do alternative service or pay a substitute fee. They didn't have to swear oaths. Religious dissenters didn't have to pay the church tax in most places by the middle of the 18th century. And there were some other smaller exemptions. There were differences in detail of Jewish and Christian incest laws, and the Jewish community in Rhode Island got to live by their own laws and not by the Christian laws and so forth. So when shortly after, some of the colonies were tolerant from the beginning, some were not. So take as the colonies that were intolerant. Once Massachusetts and Connecticut decided that they would allow Quakers to live there, very shortly thereafter they decided Quakers get exemptions for their religious practices too, because otherwise saying you can live here but you can't practice your religion would have been illusory. So I think, they didn't have to debate it in the way we debate it with a fundamental cultural disagreement about basic moral rules, but when the issue did arise, they treated religious liberty as including the right to actually practice your religion, and they wrote religious exercise into the Constitution.
Jeff, can I respond to that?
Please do. And
Since I completely disagree with that account of history.
Excellent. Tell us why.
The concept that we had a 99.9% agreement because everyone was a Protestant is the kumbaya theory of the Constitution, and it's not accurate.
That's not what I said.
That is what you said.
No, I said they were all Protestants, so the issue of exemptions didn't arise very often because of that consensus.
That is not how the Quakers and the Baptists felt about it in Massachusetts, who were terribly persecuted. That's certainly not how the Quakers felt about it in Pennsylvania, where for a good period of time you had to be Quaker in order to serve in public office. Why? Because a Quaker was someone who had come to the true faith, but the Quakers believed that you couldn't force someone to the true faith. So you had to let them come to it, and so then you could only give public office to the ones that came to. The wonderful achievement of the separation of church and state and the Establishment Clause was grounded in the very deep differences that people felt about other faiths. There was no concept of, oh, yes, we're all sharing the same faith and therefore we're going to have the same agreement. The reason there was less demand for accommodation is a combination of less regulation, but it's also the fact that at the time, during the framing generation, they fundamentally believed in the concept of too much liberty. In a number of the state constitutions, they used the phrase licentiousness. Some of the state constitutions still have the phrase that licentiousness is not protected as part of liberty, and at the time licentiousness meant too much liberty or inappropriate liberty. Most of the state constitutions limited free exercise for safety and for peace. So we've always had a concept of a built-in set of limitations that are needed for a peaceful society. And the reason we needed those limitations is in part because of the deep disagreements over faith. Those who came over here really didn't understand, they didn't bring with them a concept of separation, they didn't bring with them even the functional separation that Doug mentioned earlier. They came from a place of a theocracy, and then for many of them, they set up one over here. But over the course of time, the diversity of believers in the United States has been so pronounced to the point that now we have over 100,000 sects in the United States. It's the diversity that has led to the deep belief in disestablishment and in the inappropriateness of the government being in control. Now we have this deep diversity, and now we have many, many disputes about free exercise, but those disputes do not belong to the Constitution. Those disputes belong to federal laws like the Religious Freedom Restoration Act.
Jeff, can I just throw in 2 cents here?
Please.
Because I also disagree with Doug on this, much as I respect his learning. And I want to come in on this because we are sitting at the spot where there was a profound debate on precisely this issue of exemption. These questions weren't just resolved in ad hoc manner, one by one. In 1775, Quakers feared that they might have to fight for the United States against Britain. Many of them were Anglos, unlike the Mennonites, who are of German origin, were quite happy to see the Brits go under. And the Quakers, therefore, stood alone. And the Quakers were the leading sect demanding an exemption from general laws, asking to be free from law on account of their religious beliefs. And they protested at the State House, right here. And you know what happened in response? The entire member of the Revolutionary Committee and the Committee of Safety, all of the members of the legislature marched down Market Street in a giant parade and presented a counter memorial to the legislature protesting the disgraceful opinions, as though they thought, of the Quakers. In other words, the claim of a general freedom from law on account of your religion was very broadly discussed right here. And
then what did the Continental Congress do?
The Continental Congress, of course, allowed them to be free from fighting, but it did ask them to pay an equivalent. You don't just be free from fighting as nowadays. You have to actually pay for someone to take your place.
Well, actually, it's not quite what the Continental Congress did. What they did was that they exempted the Quakers from fighting and then called upon the Quakers to make that kind of contribution to the war effort that was consistent with their conscience, leaving it actually up to them to figure out what that would be. So it suggests to me that maybe the mob in Philadelphia and the considered judgment of the representatives of the people of the entire country were not on the same page.
I would beg to differ. Quaker meetings, especially the meetings of sufferings, have extensive records of the fines they paid for failing to pay what they considered war taxes and an equivalent.
This superb discussion.
The two of you were, Phil is talking about the Pennsylvania legislature and Michael's talking about the Continental Congress. But in our time we don't have a draft, but in my time we did, and when we had a draft, conscience objectors were exempted, but they had to perform alternative service, and everyone viewed that as an exemption and is worth fighting for. There were 3,000 reported cases in the federal courts during the Vietnam period, and that's what the Quakers got during the Revolution. They did not have to fight themselves. They did have to pay this fee to support a substitute.
This superb discussion answers an excellent question, which was how does the 1777 exile of the Philadelphia Quaker leaders to Virginia rank as a conflict over religious liberty? We need to have closing arguments because our next panel will begin soon. I'm going to ask each of you to sum up as crisply as you can. Try to do it in a paragraph, really. It's a challenge. The original meaning of the religion clauses of the First Amendment.
You know, I don't get 500 pages. I would encourage each of us to embrace the text and then look at the context. The text of the First Amendment makes quite clear that it is not offering a separation of church and state, which is actually a very restrictive and discriminatory principle. The text, moreover, of the Free Exercise Clause makes clear that it's not offering an exemption from law on account of your religion, because notice, if a law does bear down on anyone so far as to be prohibiting one's free exercise of religion, then Congress should not have made it in the first place, according to the First Amendment. So it actually precludes judicial exemptions. And then when ultimately, to back this up, needs to look at the history, and notwithstanding claims to the contrary, there is no denomination in this country demanding separation of church and state. And the only denomination seeking before 1791, and there is no denomination seeking a general right of exemption that's of any political significance other than the Quakers. And the Quakers lost that battle and continued to lose it well into the 1790s, as is evident from their records. So I think both text and context counsel for a moderate but valuable interpretation of the First Amendment.
Thanks so much for that, Philip. Michael.
I think maybe the biggest misconception of the Establishment Clause is that it was designed to build a secular society. We often hear that, and maybe the Free Exercise Clause protects people in the privacy of their homes, but the idea of disestablishment is we would have a more secular society. I think that that's a misconception in that I think that together what they were doing was they were disarming government in the field of religion and leaving whether it's going to be a secular society or a religious society or what kind of society it's going to be to the private acts of individuals and churches and institutions and whomever. That what this is it's a massive, it's a double-barreled deregulation of religion. Deregulation both in the sense of allowing people to exercise their religion, but also deregulation in the sense that we cannot use the levers of government power, including support, including financial power for the government to be able to control religion, and that it wasn't designed to create a secular society, it wasn't designed to create a religious society, it was designed to create a religiously free society, which would go whichever way. I love the Supreme Court decision and says that the American people the religion will be left, will flourish according to the zeal of their adherents and the attractiveness of their dogma.
Wonderful. Doug?
I basically agree with that. The two religion clauses are to keep government from interfering with religion, either by regulating it, penalizing it, suppressing it, or by trying to support it, because when government supports religion, it inevitably supports a particular form of religion. It interferes with the free growth and development of religion, and it effectively suppresses all the people with religious views different from the one that it is trying to support. The particular applications that were of significance in the late 18th century were those applications that were controversial among Protestants. So they fought over how to finance the church, and money directly to the religious functions of the church was maybe the central issue at the time. They fought over exemptions in the particular context where they had moral disagreements. What I said a few minutes ago was they didn't have many moral disagreements. But when they did have moral disagreements that impacted somebody's religious practice, they generally granted exemptions. They didn't grant everything the Quakers asked for. They wanted not to serve in the military and not to pay an equivalent. What they got was you don't have to serve in the military. Many of the issues in our time were not an issue in their time, right? We fight over prayer in schools. They didn't have schools, and they didn't have many non-Protestants. There weren't significant political forces that could raise those issues. But the principle that they committed to was government shouldn't interfere, and government should stay out of religious controversies.
Many thanks. Marcy?
Well, I think both Mike and Doug are fundamentally mistaken along the following line. I think it is a mistake to think that the framing generation was only interested in the protection of religion and religious liberty and not fearful of it. Religion and the state are the two most authoritative structures of human existence, and they fundamentally understood that, and in many ways had a much more realistic assessment of the way in which religion operates in the public sphere than some today. There was a need for the Establishment Clause not just to protect religion, but also to protect the state. And that's one of the reasons we have the only portion of the main body of the Constitution that deals with religion says that there can be no religious test oath. On the one hand, that protects our public officials from having to say that they are one religion or another, but it also keeps any religious entity from claiming ownership of who our elected officials are. So, so long as we understand the balance between liberty and limitation, I think that we will stay on the road to what is a miracle, which is that we have over 100,000 sects, such diversity, but we have not had a religious war. And that alone is a testimony to the brilliance of the framers, and it is my view that is this concept that there is a separation between church and state that has made that work.
Ladies and gentlemen, you've just heard a constitutional conversation conducted at the highest level. Please take a 5-minute break, just a brief stretch, and we will come back for the second panel. Please join me in thanking 4 great scholars of religious liberty. Ladies and gentlemen, welcome to part 2 of our thrilling symposium on religious liberty. I am so excited to announce our moderator, Chris Mondix from the Philadelphia Inquirer. Chris Mondix is the legal affairs reporter of the Inquirer. Before that, he served as Washington correspondent. His work has appeared in many publications, including the Los Angeles Times and the Washington Post and the Chicago Tribune. He's one of the most thoughtful legal reporters in the country. He's been a guest moderator for us before and served with great distinction. And I'm very excited that tonight is the beginning of a partnership between the National Constitution Center and the Philadelphia Inquirer. The Inquirer will supply wonderful moderators and reporters like Chris to participate on our panels. And our guests will write op-eds and commentaries that appear in the Inquirer, and we're really delighted to be able to working together to foster civic discourse here in Philadelphia and around the country. Ladies and gentlemen, please join me in welcoming Chris Mondix and his great panel.
Thank you, Jeff, for that very kind introduction. It was very interesting to listen to the first panel and to be reminded of the history of this conflict in our country between religious liberties and the protection of other people's rights who don't necessarily share the views of the person who is trying to exercise those religious liberties. And there's a long history of that in the United States, and especially interesting to hear that this notion of church and state and the separation of church and state had an entirely different, perhaps an entirely different meaning 200 years ago. So that it puts our current conflicts in some context, and we have really an excellent panel here to talk about those, where the exercise of religious liberties and the frictions that develop when persons exercise religious liberties that conflict with certain civil liberties that have been established by the court. So I'm going to introduce our excellent panel here, and very interesting group, and I will need to put my reading glasses on, if I can find them.
Borrow mine.
Thank you so much.
Oh, they're there. They're there.
Okay, great. Thank you. Sorry about that delay. Christina Arriaga de Buchholz is Executive Director of the Becket Fund and developed a lifelong passion for freedom from her exiled Cuban-American parents. At the Becket Fund, she leads a team of lawyers and communications professionals who defend religious freedom in the U.S. and abroad. Christina joined the Becket Fund in 1995 and started her career in Washington, D.C., working for the U.S. Ambassador Jose Sorzano at the Cuban-American National Foundation. David French, to my left, is a staff writer at the National Review, an attorney concentrating his practice in constitutional law and the law of armed conflict, a veteran of Operation Iraqi Freedom. He's the author or co-author of several books, including most recently the #1 New York Times best-selling Rise of ISIS, A Threat We Can't Ignore. He's a graduate of Harvard Law School, the past president of the Foundation of the Individual Rights in Education, FIRE, which I believe is in Philadelphia, and a former lecturer at Cornell Law School. Greg Lipper, to my right, is a senior litigation counsel at Americans United for Separation of Church and State. Greg joined Americans United in January 2011, and he litigates church-state cases at trial and on appeal. He's an experienced oral advocate and was named a 2013 Rising Star by the Super Lawyers Organization. Greg is currently lead counsel in the University of Notre Dame versus Burwell, in which his group represents a Notre Dame student who has intervened to protect her access to contraceptive coverage under the Affordable Care Act. And Robin Fretwell Wilson, directly to my right, is the director of the University of Illinois Law School's Family Law and Policy Program. She specializes in family law and health law, and her research and teaching interests also include biomedical ethics, Law and Science, Children and Violence and Insurance, and she has published extensively, and her work has been appeared in the New York Times, the Wall Street Journal. She's been appeared on and has been on National Public Radio, All Things Considered, and many other prominent news outlets. So that is the panel, and I'd like to start with you, Robin. I think one of the things that I find most difficult about this subject is the emotion that this conflict between the exercise of religious liberty and when it confronts somebody else's civil liberties. When you have a person like Kim Davis in Kentucky who won't issue a marriage license because to a gay couple because it conflicts with her religious principles. Yet this issue seems to have been addressed in Utah by the Utah Compromise, and I was wondering if you could tell us how that works and how well it's worked.
Well, happy to do that. I think the first thing to do, though, is to back up and talk about Kim Davis and what I think the problem there is. So, you know, when you advance a thick notion of religious liberty, that my rights are so great that I get to block you from your rights, we get to collision points that are really awful, and actually, I think it's just been a really ugly chapter, frankly. And not the least of which is for those advocates of religious liberty. She's setting religious liberty back by making such a big claim. The state has monopoly power on marriage. Nobody can be a choke point on the path to marriage once the state has decided that folks get to marry. You can disagree with that. You can step off from that, but you don't get to block other people and their access to it. And that was actually the intuition that the Utah legislature had. They found themselves 6 months ago where the country finds itself after Obergefell, which is with the same-sex marriage decision that they really weren't ready for. That state actually had a constitutional amendment that had been struck down by a federal district court, upheld by the 10th Circuit, left in place when the Supreme Court first denied cert. And instead of saying, we're going to allow someone to block access to others, they said something different. They said, we get that there are people like Kim Davis, especially in Utah, because Utah is the second most religious state in America. So you know in many places in that state, there'll be folks that just can't get with gay marriage, whatever you might otherwise think about it. And so they said, we don't want to fire people like that, but we absolutely have to provide access to lesbian and gays to marry, because the law says that's the case. So for the first time, they enacted in Utah law a process to make sure that anybody who presented to the state could be married. That had not been there in Utah law before that. But then they did something important. They decided to outsource, or at least allow the outsourcing that function, to any authorized celebrant, i.e. a minister, a mayor, whoever's authorized under Utah law to marry folks in that community. And those folks just had to agree to it. If that's the case, then you never have Kim Davis getting fired. And neither do you have Kim Davis standing at a desk and telling people what she thinks about them or their marriage, which I think is really inappropriate for, frankly, somebody who's paid by those citizens, right? So you don't have either side losing. But that requires compromise at the front, and it requires thoughtfulness. It also requires getting in front of problems and not waiting until they blow up on you.
Right, but that wouldn't satisfy. I'm wondering whether that would work in other states where you have really well-organized opposition and just very fervent opposition to gay marriage. Here you have simply the government function being outsourced to some other entity. What were the politics like, if you're up on that, in Utah that permitted that to happen there, but perhaps not elsewhere?
I think I'm up on it because I spent 3 weeks helping them enact it towards the end of the Utah. If anybody's, except for them, they would be more up on it than me. But, you know, look, one thing that was really important about Utah is that the LDS Church actually in January said that it wanted to find common ground. It wanted what they call a fairness for all approach. And what they meant by that was, and the big three things that we deal with in anti-discrimination law: housing, hiring, public accommodation. They recognized that public accommodation, things like restaurants and bakers, that was going to be a really tough lift for them. But they also recognized that there was really not a lot of reason to say to the LGBT community, y'all shouldn't live in this apartment complex, or we don't want you working at the burger restaurant, right? So they decided to find those areas of common ground, hiring and housing, and to advance the rights of the LGBT community. In Utah, literally the most conservative state in America, gave more protections to the LGBT community than New York does expressly in its law. That is profound. But they also came back with that exchange and negotiated more protections for conscientious dissenters to marriage, i.e. people who are still believing in the traditional view of marriage, not the new view of marriage. More protections for them than any state in America up to date, right? So both sides won. And that's actually what I think is really unfortunate about the Kim Davis affair, because here's somebody saying, protect me, while not talking at all about the interests that other people have. Utah cut new ground. They said, let's advance the rights of the LGBT community while protecting people's ability to step off if they are deeply divided and still wed to a different idea of marriage.
Very interesting. I'd like to ask David French, who's written about Kim Davis and compared her and I think Ted Cruz to the early religious reformers, Martin Luther and John Calvin, which I thought was a really interesting argument, although I think a bit of a stretch in a way. But interesting nonetheless. How do you respond to...
So you're saying John Calvin would have given the marriage
Well, I
license?
don't know. I wondered what would have happened if Martin Luther had gotten a religious exemption. Would that have...
So, you know, we need to remind ourselves of the facts of this case a bit. Number one, Kim Davis, the core problem was that she was not allowed an accommodation where the marriage license could not go out under another person's name in her office. And so that was the key issue. The key issue was not she's going to stand and stop gay marriages in Rowan County, Kentucky. She didn't have that power. Somebody could go to the next county and get married and come right back to Rowan County. From not far from Rowan County, and Kentucky is a small state with 129 counties, and so you're never more than 30 minutes drive away from another courthouse. So she was not blocking people from getting married. Her desire was to not have her signature on the marriage license. That is a very different thing from saying I'm blocking someone from getting married. Now, she was not granted that accommodation, and she did what, she didn't buy into the binary, the choice that other people put before her, which was comply or resign, which is not the traditional Christian response to when one is in a position of public authority. That's just simply not. In fact, in the history of the Protestant church is quite clear that when there was a secular attempt to require people to violate their consciences and their rights of free exercise in particularly cities in Northern Europe in the Reformation and the onset of the wars of religion, that they said no. And in fact, I've got a kind of a nice quote from John Calvin here I would like to read. And,
Sure.
And Calvin is a little bit, fortunately, I'm not quite there yet where I have to have those. And now this is Calvin being Calvin. He had a salty way of speaking by 17th century standards. True it is, God has commanded kings to be obeyed, but likewise true it is that in things which they commit against his glory, he has commanded no obedience, but rather he has approved, yea, and has greatly rewarded such as have opposed themselves to their ungodly commandments and blind rage. He later goes on to say, we ought rather spit upon their heads than obey them. So the notion here is that each level of government has its own independent responsibilities to God. And to tell Kim Davis that she cannot and must not exercise that is going to mean that Kim Davis is going to simply say, well, I'll go to jail before I agree, which
Right.
is what she did.
I'm just curious, what in your mind is the practical alternative? If every clerk in that office said, I can't do this as a matter of conscience, and the law says these people are entitled to their license.
Accommodations here are almost pathetically easy. You can have an online system of marriage registration. You can go to the next county. North Carolina passed an accommodation statute like that. There's many ways to do it where the religious conscience of the public official is respected and the person gets their marriage license. If the desire here is ideological domination and control, you're going to have this conflict again and again and again. If the goal is to respect conscience while still giving people marriage license, simple.
And it's your belief, and correct me if I'm wrong, you've written that the tenor of this conflict between the exercise of religious liberty, particularly for Christians, and the government dictates has reached a level that is unprecedented in our society, in our history. And do you feel that way? Or?
I think we're getting to the point, I wouldn't say it's unprecedented. I mean, I would take slight issue with the notion that we've not had a religious war. The American Civil War actually had an enormous amount of religious underpinnings to it. There was a huge faith conflict inherent in that war. But I will say this, as the government grows larger and larger, it is inevitably going to intrude more upon the lives of faithful citizens. And faithful citizens will not yield to the government, period. And so you're either going to have to figure out accommodation, or you're going to have to experience schism. And that's going to be your options. This is not, and when we're talking about infringing upon things that, respectfully, I disagree that this set back religious liberty. I think when you talk about, many people are saying, oh, only a minority of people support it, or 25% of Americans. That's 80 million people who supported someone in the stand that she took, to the point of going to jail to protect her conscience. And when we're dealing with that, the state either has to become domineering and oppressive, or we have to reach some sort of accommodation. Those are the only options.
Thank you. Greg, I wanted to ask you, you look like you're ready to respond, so I'm just going to let you jump in.
I mean, I think David's comments are rather breathtaking in a number of respects. So I think the first thing is we can, and I think we should accommodate religious exercise and religious objectors when we can make religious accommodations that protect everyone's rights. An accommodation that says, I get to close my office, you can get your marriage license in the next county, I don't think achieves those goals, just like after the Supreme Court in 1967 said bans on interracial marriage are unconstitutional. I don't think anyone would suggest it would have been an appropriate accommodation to say, well, you can't get, an interracial couple can't get their license here, but it's okay, just drive 30 minutes and get one there. So I think, it's a two-way street. Kim Davis could have requested an accommodation. She could have requested permission to have her deputies issue the licenses and sign their names. That's not what she did. She shut down her office. And even after a court order would have allowed her to stay out of jail by simply not interfering with her deputies, she refused. So, I mean, unless we are going to live in a theocracy, accommodations cannot be absolute. It cannot be that simply because I have a religious objection to a particular course of conduct, be it marriage between a same-sex couple, marriage between people of two different religions, marriage between an interracial couple, there needs to be give and take. What David is arguing for is simply the religious objection wins. And I have a feeling that it's only certain types of religious objections. For instance, in states before the Supreme Court's decision when same-sex couples could not get married, there were actually lots of pro-LGBT clergy who felt a religious obligation to perform those marriages. I do not recall hearing David and his friends saying that they were being oppressed and that the government should accommodate them by recognizing those marriages. So I think, again, we have a lot of different religious beliefs about sexuality, about marriage, about all sorts of things. Accommodation, I think, is appropriate when reasonable, but reasonable accommodation does not mean I get to impose my religious beliefs on everyone else, period, full stop, and that seems to be what David is asking for.
Well, I would welcome your use of Google to find a single instance where I advocated against religious liberty, exercise left or right. So it's simply not the case that I support the exercise of religious liberty of those people who agree with me substantively. And so I think that I would remind everyone that I said that there were easy solutions here to allow both her exercise of religion and the receipt of the marriage license.
Why didn't she ask for one? Why did she shut down her office entirely?
She was not permitted to change everything was going to have to go out under her signature. So even if a deputy clerk, so you're a senior attorney, someone signs your name to a brief, it's your brief, right?
But if I have a conscientious objection to a brief we're going to file, I go to my boss and say, I don't feel I can sign this. Can my colleague sign it?
Your name.
Hold on.
Your
No,
name.
can my colleague sign it his name? What I don't say is, not only am I not going to sign it, but I forbid any of my colleagues from signing it. Instead, we need to
It has
close-
to be her name.
But
Her name.
she's never asked for that. I mean, that's the thing.
Yes, she did. She asked for it.
But before we get into the weeds and the grains in this, I want just as looking at this from afar, the exercise of these religious ideals and principles seems wonderful theoretically, but it also sounds, doesn't it? And I'm going to pose this question to Christina. Like a recipe for chaos if taken too far. Or do you disagree with that idea?
I totally disagree. Yes. This reminds me of growing up in Puerto Rico, talking to my family. It's great. It's great that we can have a robust debate and not get arrested on the way out. My mother was in a concentration camp in Germany, by the way, Catholic. They also imprison Catholics. And my father escaped Fidel Castro's Cuba. And when we first arrived to Puerto Rico in exile and in poverty, we lived in a very small townhouse with no central air conditioning, but my father insisted when he came in every day that we would close all the windows. It was hot as Hades there. I didn't say hell because there are religious people in the audience. And we spent, and after a while, after years, when my parents realized that they were not going to suffer imprisonment if they said something that the neighbors disagree with, it may have been months. It was very hot, so it felt like years to me. We drank from the fountain of freedom of expression. We talked about the sexual revolution and politics and religion, and we disagreed. My family spans fascist to communist. Hopefully they're not watching because they'll get into an argument with me about how they span politically. What this country guarantees is the ability to not only have different views, but live according to those views. I'm always moved when I come to the National Constitutional Center and I see the documents that track the fact that Quakers didn't want to take an oath of office. Our Constitution itself accommodated for that by putting in the word affirm. I mean, if that doesn't bring you to tears about the commitment of our founding fathers for freedom, then what does? In the whole state of Kentucky, there wasn't one single person that could issue that little piece of paper. It had to be her. And whether she handled it well or not, whether she should have locked her office or assigned her deputies, the fact is that the second she brought this up, there should have been an active process of changing the word oath to affirm, or giving her the opportunity, or accommodating. That is not only reasonable, it's constitutionally protected.
So you and David are saying that there are ways, there are accommodations, there are end-arounds that can satisfy both sides in a matter like this. Is that correct?
Absolutely. We just saw Robin Wilson talk about the Utah Compromise, and people are not always happy. I mean, I should sit at the feet of Doug Laycock, who's one of the people who have argued so effectively about this. I mean, he's for same-sex marriage. He is also for accommodations. When there is a conflict between two people that are making mutually reinforceable claims having to do with identity, our law allows us to resolve those conflicts. There doesn't have to be an imposition from the religious side, and there certainly doesn't have to be an imposition from the government side.
Robin, you're about to jump in with a point, I think.
Yeah, it's a tough crowd to jump in on. But
Yes.
let me just say, look, we're conflating two different things. So one is, how do you get this piece of paper to the gay couple that is now entitled to marry? Okay, and I think the better analogy even than interracial marriage, right, is when Kim Davis shuts down the marriage function in that part of Kentucky. By the way, it's 30 miles to one office, 50 to another. She's shutting down marriage to everybody. And the state has monopoly power on marriage. It's not acceptable for the government to shut down a function entirely because one person objects. She doesn't actually need an accommodation for the idea that she doesn't want to be the one who handles the paper. It's already there in Kentucky law. Go read it. It says either the clerk or a deputy clerk may issue. So she's out of that box without anything from the legislature. She could have done that, but she would not accept that. That's the thing. She's so bitterly opposed to same-sex marriage. She won't do it, and she won't let anyone else do it too, and that's the problem. Now, when I say she doesn't, she set back the cause of religious liberty, I'm going to stick by that. Because frankly, I can't get in a room with legislators now and sit there and say to them, geez, you know, there are a lot of clerks that are bitterly opposed to this, and can't we just keep them from being fired? So what I would say in Utah, for example, is I always talk about 4 clerks. Let's talk about them as faith, hope, charity, and efficiency. And the only one who objects to gay marriage is faith. Right? Can't we possibly allow her to keep her job and still have gay folks getting married? And Utah found a way to do that by bypassing the problem of faith being an objector. She kept her job. That's consistent with a tradition in America to staff around religious objectors even when they work for the government. But now I have Kim Davis, right, who has put a really ugly face on the idea that faith should have not been fired. Some of these clerks, by the way, started in these jobs long before gay marriage was recognized anywhere in the world, right? We don't want to deny them their livelihood. We don't want to kick them out of a job that can be done another way. But they can't be a choke point on the path to marriage. Nobody gets to do that, even faith, even Kim Davis.
I'd like to ask Christina a question. You say that there are these end arounds that are available. And it seems to me that the Obama administration offered your clients, the Little Sisters of the Poor, an end around by signing a certification that exempted them from this contraceptive requirement, and yet you're litigating on behalf of their objection to this. Now, I understand the principle of it. It's interesting, but the 10th Circuit, I think, said in its decision that's really, it's like getting a parade permit. I mean, how burdensome is that, and why is that a problem?
Actually, condescendingly, the government said this was like fighting imaginary dragons when they argued against the Little Sister. I told Greg earlier that he's my favorite frenemy, so I always like to be on panels with him. Last year, when we were debating this, he said that the Little Sisters were unreasonable because they were not signing this form. And I said, well, I agree with you. Little Sisters are indeed unreasonable. You only get one life, and they devoted in poverty, chastity, and obedience to help elderly poor die. Elderly poor die. No one dies alone in the houses of Little Sisters of the Poor. That means they hold the hands of people who are terminally ill. And they live according to their principles. They believe in the sanctity of life from the beginning to end. Now, the government tells the Little Sisters, unless you distribute contraceptives and abortion-causing drugs, and by the way, this is an FDA, the government has said that there are 4 drugs in this panel of 20 drugs that cause abortions. Unless you give them to your employees or you allow your third-party insurance, which by the way is also a religiously based insurance, unless you allow that plan to be commandeered by the government, we're going to fine you. We're going to fine you into the hundreds and thousands of dollars every year and close down your ministries. How is that our U.S. government? How is that our democracy? Also in the 10th Circuit, 5 judges dissented and said the judiciary doesn't get to tell people what their religious beliefs are. Every single judge on that panel, whether they were for or against the Little Sisters, did not question their sincerity. They thought it was absurd that they would say, well, hell no, I'm not going to sign that form. They probably did not literally say that, but they're not going to sign the form, and they shouldn't have to, because the government has also exempted millions of Americans from having to comply with this same mandate. Exxon, Pepsi-Cola Bottling Company, all exempted. Bishops are exempted. Churches are exempted. Why do they need Catholic nuns to distribute and offer contraceptives? Any employee of the Little Sisters can go buy them themselves. Every employee of Little Sisters can go to a Title X funded, taxpayer-funded clinic and get those same medications for free. Why is the government going after Little Sisters? That's the real question.
I'm sorry, go ahead.
So a couple of things are going on here. You notice the ease with which Christina conflated. She doesn't want to make this about signing a form for an objection. So she says, why are you forcing us to distribute contraception? The whole point of the exemption is, no, we are going to relieve you of the objection. If you write us a letter saying, we object to providing contraception in our insurance plan, you will not have to provide contraception. So no nuns are being forced to distribute contraception. they're being asked to request an exemption. Imagine, if you will, that a conscientious objector said, not only do I refuse to fight in the war, but I refuse even to request an exemption because I know somebody will be drafted in my place. Or if I were a judge and I'm opposed to the death penalty, I said, not only do I refuse to hear a death penalty case, but I refuse even to recuse myself, because if I do that, the case will get assigned to a different judge, and the death penalty might get applied, so I'm just going to let the case sit here in my courtroom languishing. Because that's what Christina's clients are doing, that they are refusing to request an accommodation, they're refusing to request the exemption, because not only do they refuse to distribute it, which is fine, which is the right they've been given, but they are trying to block a third party from distributing it. And their employees have rights as well. The IUD, for instance, which is the most effective form of contraception, is expensive. It costs over $1,000. So it's not enough to say, oh, employees, just go buy it yourself. You know, the solution that, oh, just go on public assistance and get it that way, you know, that's kind of not how it, that's not how it works. And it's very hard to imagine that being said about any other type of healthcare. If a white man was told, I know you really need to have that colonoscopy, but just go on public assistance and get it that way because I refuse to request an exemption, that would be laughed out of court.
Colonoscopies, really?
So,
Really?
No, but I mean, you know, people have religious objections to all different types of healthcare.
To colonoscopies.
Excuse me?
People have religious objections to colonoscopies.
People have religious objections to vaccines, blood transfusions, and there are some people that have religious objections to all medical care. There are people with religious objections to gelatin-covered pills or to surgical sutures made from pork products, which is fine. The Little Sisters are being given an accommodation, but they are saying, I refuse to even request it because I don't want a third party to provide that coverage. And this, I think, goes back to what Robin was saying, which is, look, you can be accommodated, you should be accommodated when reasonable, but you don't have the right to be a choke point, you don't have the right to block someone else's access. Religious objections don't trump all other interests, including women's interest, you know, in affordable contraception. And so again, I think it's a question of are we going to have a reasonable accommodation scheme that respects everyone's interests, or am I going to insist that my religious views trump everyone else's rights? And when that happens, the long-term support for religious liberty dwindles, as we're already starting to see, and that's a tragedy, but that's what's starting to happen.
I'm just going to say one thing. Millions of Americans were exempted without having to sign a form.
They were exempted.
And if the form is meaningless, why is the government forcing the Little Sisters to
because
sign it?
The government
It triggers their insurance plan, and the government has said this very clearly. And in their last submission to the Supreme Court, they said this very clearly. They admitted that they would have to commandeer the insurance plan of the Little Sisters in order to distribute these drugs and devices. None of the other groups had to sign any form telling the government anything.
So let me address a couple of things. Why do they need to sign the form? Because you need to know who gets the exemption. Very simple. The assumption
Look at
is,
them. Do they really need to tell the government that they want an exemption?
Hold on. The default rule is either you, the employer, provide it. If you don't want to provide it, fine, tell us, and we'll get someone else to provide it. So I think that's thing one. The millions of exemptions that Christina keeps talking about, it's a great talking point for her, but it's a transitional measure. In other words, if there's a grandfathering provision. If you had a plan that didn't cover contraception, you can keep that, you can maintain that plan unless and until you make any other change, then you do have to cover it. Christina's own client, Hobby Lobby, said in court, in fact, Christina's own lawyers said in court, the grandfathering exception is not a permanent exemption, it's a transitional measure. So she's really comparing apples to oranges here. And again, I asked Christina, should the conscientious objector be exempt even from requesting an exemption? Should the judge be exempt even from recusing, allowing himself to keep his case unadjudicated in his courtroom? Because that's precisely what she and her colleagues are arguing for in court.
I think Robin would like to jump in with something.
You got to have permission to get in on this. So, look, you know, doesn't this sound, and you know, I'm deeply sympathetic to both sides, okay? Christina knows that as well as anyone, that I've worked very hard for actual religious liberty provisions. I completely get where Greg is in thinking that women need contraceptives, okay? In fact, you know, I just think those are no-brainer propositions. We have to break impasses like this, though. I mean, this isn't really hard in a sense. So that there's a technical provision in ERISA which says that these plans can't be changed without the basic person who is in charge of the plan having something to do with that, right? And you have the Obama administration, to its credit, having said, wow, we get that there are religiously affiliated groups, not just churches, that are going to have problems with some of these drugs because they see these drugs as ending a life and being. And that's a serious thing. We've always taken objections to abortion seriously in the United States. We've done that since Roe v. Wade. But somebody ought to just change the law that says that this can happen as a matter, an operation of law, and bypass the sisters entirely. And then everybody wins. It's not like complicated. Now, unfortunately, because we're talking about ERISA, we're talking about federal law. And I don't know about you, but I haven't noticed that the Congress has done anything recently. Right? But this isn't rocket science. If we were in Utah and we had a problem like this, you'd sit down with one set of guys and go, geez, isn't there like a common sense way for these people to have this and those people to have that? And we can creatively get there without anybody having to get their hands dirty as a matter of their religion and women not having to
And
go
Robin,
that
very briefly, what would that look like?
Well, I mean, I think Congress can just change this provision of ERISA law that says that the plan can't be changed unless the sisters get in on that, right? Why not just bypass that? Or for that matter, why not have some sort of notice provision that says the first time an employee of the sisters says they're not getting this from the sisters directly, the employee can put the government on notice, right? Why has it got to be them having to tell the government? I mean, but the point, I don't know that I have a perfect answer, but the point is there is an answer, right? We can do this, and it's just a matter of political will, and we can stop litigating, and that would be cool.
David, you have something to add?
Yeah, let me back up for a minute on this. This is going back to what I said earlier. As government gets larger and larger and larger, we're going to have these conflicts. So let's look at this notion of a right to contraception covered, provided free by your employer or facilitated in some way by your employer. Where's that right? That right is an HHS rule. It's not a statute passed by Congress. Everyone calls it the Obamacare contraception mandate. It's actually a regulatory initiative. It's something that HHS made on its own without going through Congress. And so on the one hand, you have a right to free contraception that was created 9 seconds ago, and you have the 200-plus year history of the free exercise of religion. And then it's phrased as, well, these are equivalent competing rights. I mean, on college campuses, we've had these kinds of battles for some time. 15 years ago, there began to be a right that was existed for someone who did not believe in the tenets of the Christian faith to be eligible to lead Christian organizations. So an atheist should be eligible to lead a Christian fellowship. A Muslim should be eligible to lead a Jewish organization. And it was phrased as competing rights. It's your right to free speech and freedom of association, free exercise of religion, versus this person's right to be free of discrimination. Where did that come from? What are we talking about here? Where's the government interest in requiring a non-believer to be eligible to lead an organization of believers? Yet that went all the way to the Supreme Court of the United States, and Supreme Court of the United States said, yeah, under certain conditions, the state can, in fact, require a Christian organization to be open to non-believers, even in positions of leadership. And so when you are a believer and you're looking at these battles of quote-unquote competing rights, what you're often seeing is on the one side, you have historically exercised fundamental foundational rights that existed and are part of the very fabric of our society, and without them, this nation would not have been built as a united nation. And then on the other hand, you'll have some college campus somewhere, some federal agency somewhere is going to create a new right. And then we treat this as if, well, it's just the same thing, one going against the other, potato, potato, tomato, tomato. Who's going to win? And we have to understand, where are the rights that knit this nation together, that without them we don't have a nation? And if we continue to push and cause those rights, those fundamental rights, to retreat and to retreat and to retreat, you are going to fray the very fabric of this country.
David, you're bringing me right to we're running out of time, and I'd like to touch on one last question, and that is one issue before we get to the questions from the audience, and that is the issue of federalism. There are many people who make the argument, and I suspect you do, that many of these issues can be but addressed by state legislatures. And indeed, Ruth Bader Ginsburg, the leading liberal on the United States Supreme Court, said that probably would have been a better way to handle Roe v. Wade at the time, although she's moved away from that view on other volatile social issues. So I was reading through Justice Scalia's dissent in Obergefell versus Hodges, and it was scathing and scorching. It really took me back, and it was interesting because Roberts' dissent was very, very long and said essentially the same thing. Scalia said it in a third of the space in a much more pithy way. And I'll read some of it, and I want to get the reaction to the panelists. Scalia said at one point, today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of 9 lawyers on the Supreme Court. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776. Then he goes on to say, it's a two-barreled blast where he attacks the court's reasoning, which he describes as a judicial push at one point, and then attacks the nature of the court itself. He says, it consists only of 9 men and women, all of them successful lawyers who studied at Harvard and Yale law schools. 8 of them grew up in the East and West Coast states. Only 1 hails from the vast expanse in between. I think that's John Roberts. Not a single Southwesterner, nor even, to tell the truth, a genuine Westerner. California does not count. I think he's right about that. Not a single evangelical Christian, nor even a Protestant of any denomination. Greg, what's your reaction to that?
I think Justice Scalia should and probably does know better. I mean, the Constitution, the point of the Constitution, and in particular the Bill of Rights, is to protect minority rights. We do not live in an absolute democracy. You know, Brown v. Board of Education overturned democratically enacted laws creating racial segregation. Loving versus Virginia overturned democratically enacted laws banning interracial marriage. Justice Scalia regularly joins 5-4 decisions in which 5 lawyers strike down duly enacted statutes, be it campaign finance regulation or the voting or provisions of the Voting Rights Act or all sorts of other things. So, I mean, to say, how dare the Supreme Court overturn an act of the people or act of the legislature is sort of besides the point. The point is the Bill of Rights says that there are certain civil rights and civil liberties that trump, in some circumstances, the will of the people, and then the court has to figure out when that has happened and when it hasn't. And I think in the case of marriage equality, you had discriminatory bans that were justified by religious objection or moral disapproval, but not justified by any legitimate state interest. The arguments that were made in defense of those bans were almost laughable. And people are entitled to have religious objections to marriage equality. They are entitled to, no one's forcing anyone to marry someone of the same sex, but that isn't a reason to deny other people that basic right. So I guess at the end of the day, I'd say Justice Scalia kind of should know better about the purpose of the Bill of Rights and the importance of a court protecting minority rights from what are sometimes the excesses of popular rule.
Thank you. David?
I would say Justice Scalia was almost right. He didn't go quite far enough. And I think it's fitting from the audience perspective that we've got the far left here and the far right. I think what we have seen is, in essence, over the last several decades, is the establishment of a judicially created religion from the United States Supreme Court. And what is the Apostles' Creed of that religion? It is the sweet mystery of life passage from Planned Parenthood v. Casey. For those of you who don't remember this is at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. That is not a constitutional principle. That is a moral declaration, one that would actually sound more kind of like the ones you would hear in a late-night dorm room bull session, not in a opinion of the Supreme Court of the United States interpreting the actual provisions of an actual written document. And when you break that down, that concept of liberty is fundamentally opposed to most Orthodox religious faiths. In many ways, it's even opposed to a scientific atheism. I mean, at the heart of liberty is the right to define one's own concept of the universe. Does that mean I can look up and I can say, you know, that Milky Way really is made out of milk, dudes? I should be able to teach that. It's my concept of the universe. I mean, that's what we're talking about here, is we're talking about the Supreme Court having dipped into the world, not of interpretation of a written document that has a history, has words on a page, but rather using the existence of that document as a launching pad to establish a new secularized American faith that happens to conflict with the Orthodox religious faith of tens of millions, if not more than 100 million of its citizens, creating an inherent constitutional instability in this country that will either have to be resolved or lead to ever greater division.
So for the legal scholars on this panel, we have a couple of questions from the audience. I'd like to just pose them a couple very quickly because we're running out of time. One of them is, how can a corporation have religious beliefs? I guess is
That's a very good question, and I think how can a corporation have religious beliefs? So one of the threshold questions in the Hobby Lobby, which was the first of the contraception cases to get to the Supreme Court, was, can Hobby Lobby, a for-profit corporation, assert free exercise rights? Its owners have free exercise rights, certainly, but the bedrock of corporate law is that owners are different than their corporations. The example I always give is if I were to be run over by a Hobby Lobby delivery truck and then sued the owners of Hobby Lobby, I would be kicked out of court because my claim is against the corporation, not the owners. And so what the Supreme Court did is sort of basically said, well, the owners have religious beliefs and therefore the corporation has religious beliefs. I think that certainly never before had a for-profit corporation been given free exercise protection, and I think it's unprecedented, but I think there's the practical harm, which is, even so-called closely held corporations like Hobby Lobby employ over half of the nation's workforce. And if they are going to be entitled to exemptions from laws protecting worker safety, equal, non-discrimination, minimum wage, overtime pay, the list goes on and on. The use of religious exercise claims to harm third parties is going to expand dramatically. And I think that's ultimately the problem with that decision, is it gets the balance is out of whack. The beliefs of a company's owners are now being used to impose on those employees without any protection for their interests.
Christina?
Wait a minute, she's not a lawyer.
That's
Didn't
right.
she start on? So
I
that
am
makes-
not a lawyer.
She's not a lawyer.
But she's a citizen and certainly entitled to have her
Cubans
opinion.
get to play lawyers
Right.
on TV. So in the case of Hobby Lobby, the Green family started a small business out of their garage. I don't know how many businesses start in garage because I keep hearing people starting businesses out of the garage, but apparently it's quite common. And they started with micro frames, and they grew that business from 5 from their family to 26,000 employees with stores in 43 states. Now, they ran their business according to their Christian principles. In fact, they said when they started the business that this was a form of ministry. They gave Sundays off. They played nothing but Christian music in their stores. They didn't have lewd cards or lewd signs. They had wonderful benefits for their employees, including a terrific health insurance plan. They only demanded their managers work 66 hours a week because they wanted to make sure, at maximum, because they wanted to make sure that they were spending time with their families. They paid twice the minimum wage, all because they were guided by the Christian principles. So when HHS created this new requirement that they had to give out these 20 drugs, the Greens said, we have absolutely no problems with 16 of these. We cannot just give 4. We don't mind if our employees go get them. We just cannot pay for them. And the government said, fine. you get to pay $1.6 million per day in fines. We'll drive you out of business. There was no reasonable accommodation for them. By the way, since then, Greg mentioned that grandfather plans will expire. Kaiser Permanente had a report last year. Because of financial reasons, they were not giving out the 20 contraceptives. And the military doesn't give out all the 20 contraceptives. And yet, the government decided that because of the reasons that the Greens did this were religious reasons, they had to be fined into compliance. And of course, as you know, the Supreme Court said that that could not happen, that there were other mechanisms and other ways that the government could distribute these drugs without having to involve the Green family.
So we have
Robin,
time
is that lawyerly enough?
It was close, but let me add just one thing. It was really good. It was
Thank
an
you.
A answer. A answer.
A minus maybe?
A minus.
I might give it a lower grade.
No, but stop. No, look, this is a statutory interpretation case. And there's a fatal concession that happens in Hobby Lobby. And it comes from the Obama administration's own concession. They said to the Notre Dames of the world, you guys, are going to be accommodated. And then when the Solicitor General was asked point blank whether a nonprofit like Notre Dame counts as a person, but your client would not, Varelli says, well, of course nonprofits count. And so what is the majority's response to that? There is no conceivable definition of person that includes a nonprofit corporation but doesn't include a for-profit corporation. And they have other arguments too. I mean, they say you shouldn't force the owners of these closely held corporations in order to benefit from RFRA's protections to forego the advantages of the corporate shield. We shouldn't put religious people to that test, they say. So I think, it seems wrong to lots and lots of people, the idea that this closely held corporation can have, religious protections under this federal statute. But when you trace it out that way, it's really not so hard to see why the majority wound up where it did.
I think we've got time for one brief response to that, and then I think we're going to have to wrap up.
I would like to weigh in on this
Sure.
just super fast.
Right.
This is the era of corporate values, right? I mean, Indiana passes the RFRA statute, and what happens? Salesforce.com comes sailing in, Apple comes sailing in. This is against Salesforce values. This is against Apple values. Starbucks was going to have its baristas introduce the nation to conversations about race. Walmart stopped or helped pressure the amendment of Arkansas's RFRA. And everyone understands that, well, these corporations have a point of view, are articulating particular values. That's freedom of expression. It's part of this rough and tumble of democracy. But then when a corporation comes of these same issues of equal moral weight from a perspective that's explicitly religious, it's like, oh, but not that kind of expression. Go Apple, Hobby Lobby, what are you doing here? That makes no sense at all. And as far as can a corporation express a religious belief, well, every church I've been a part of is a corporation, every single one of them. And yet nobody says, well, how can this church express religious beliefs? The trick here is that for-profit part, which is a completely arbitrary division in the tax code that is actually for-profit companies have greater liberties than nonprofits. So for example, a nonprofit is prohibited from actively engaging in political endorsements. For-profits have no such prohibition. So the for-profit structure in the history of the United States actually gives greater liberty in expression than the nonprofit. And so how can a corporation have religious beliefs in the same way that a corporation exercises any other First Amendment value?
I want to pick up on one thing Robin said, because I think it ties the reasonableness and balancing thread together. So Robin said in another part of Hobby Lobby that what Hobby Lobby argued is, look, you've offered this accommodation to nonprofit organizations like Notre Dame or Little Sisters, and so we should be entitled to that accommodation as well. And five justices agreed with that. But now, all indications are Hobby Lobby is going to turn around and say, no, signing the form is no different than giving out contraceptions.
That's not true. They have not made a statement on that, so don't go with all those
let
indications
me-
because there are no indications.
Let me say this.
Yes.
I've asked Christina and her colleagues probably a dozen times by now, is Hobby Lobby going to accept the accommodation? And I've never received a straight answer, so read into that what you will. And I think, we'll see what happens, but I'd bet, dollars to donuts that Hobby Lobby is going to be back in court saying filling out this form is the same as distributing. And I think this ties it together, that I think good faith accommodations can be had when both sides are operating in good faith. But when an objection is raised and an accommodation is offered, and then the fact of that accommodation is used against the government, and that even the accommodation is rejected, and in the meantime, Hobby Lobby's over 10,000 employees are losing access to contraception coverage or other health care, I think at that point the balance is out of whack. Religious exemptions and accommodations have an important role to play in America, and they have a distinguished tradition, but they've always been balanced with the interests and rights of third parties, and that's what seems in some cases to no longer be happening. And when that balance gets out of whack, the broader support and consensus in favor of religious liberty suffers, and that is ultimately the serious tragedy of it all.
Well, Greg, as they say in cable television, you've had the last word, but I'm sure this is a conversation that will be going on for quite some time, and I want to thank the panelists. What a fabulous conversation.
Thank you.
Yeah.
Thank you.